Hey everyone, it's Rob Ryder on Thursday, April 7th, 2016. Wanted officers of the United States. Usurpers need not apply. If you know any, why don't you have them watch this video? Why don't you have them email me at courtofrecord@aol.com. I'd love for them to take my complaint. Because who has an extra duty to execute and enforce the laws of the United States? Well, the answer is it's officers, of course. It's just that most of the ones that are appointed apparently have not been appointed properly. And I talked about that in my last video called Buckley. It was the last one I uploaded. So if you were searching by upload date on my site, you would be able to see the one I'm talking about, which will cover some of the things I'm talking about now, Reader's Digest version, in a little bit more detail. But you don't really need it all, except for one part that we'll get to in a second. In the meantime, if in your means, would you please donate? Because I could certainly use the help. The PayPal account is Ashley Rytlewski, ASHLEYRYTLAWSKI @gmail.com. That is the email address, or that is the PayPal account. And snail mail is to myself, Robert Rytlewski, obviously Rob Ryder's an avatar, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. Why don't you just pause the tape for a second and write those down, and well, we'll still be here when you come back. Because next we're going to talk real quick just about Article 6 of the Constitution. Now, not the Bill of Rights part of the Constitution, which I haven't ever checked this out, but I know this. You know, the word bill is a petition. Bill of Rights, so you're petitioning for these rights, and I don't have rights from the Constitution. Right? The Constitution protects my rights, which are unalienable and guaranteed by the Declaration of Independence. And all the Constitution is the shield to shield my unalienable rights from being violated. It doesn't seem to be working very well, but that was the idea. So this is Article 6 of the Constitution, in which it says, "The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." What's the supreme law of the land? The laws of the United States. And it affects the judges in every state. Even if they're not state judges, just judges in every state. If they're in the state of Michigan and they're saying they're a judge, well then by God they're bound to adhere to the fact that the supreme law of the land is the laws of the United States. To not do so would be a violation of my Article 6 protections under the Constitution. Or by the Constitution. Not even under the Constitution. By the Constitution. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as qualification to any office of public trust under the United States. Okay, so not just the judges, but all executive judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support the Constitution. And therefore, the supreme laws of the land, which are the laws of the United States. So, you know, don't use state law, use federal law. Now, what would those be? Well, okay, you could say, well, here's one. This is the Constitution. If I accept your oath and I bind you to it, remind you of your constitutional duties to uphold the Constitution and enforce the supreme laws of the land and protect me from this color of law action I'm involved in, well, now the judge got a job to do. Because everything that you're involved in these courts is a simulated legal process under color of law, because the attorneys are using middle initials and they're not filling all the paperwork right. There's omissions on it, and the name of the court isn't proper. There is no court of the state called in the, I-N-T-H-E. There is no in the. But you look at the top of your damn court documents. In the circuit court for the 16th Judicial Circuit, or in the district court of the 47th District, or whatever the hell it is. There is no in the. That's not the proper name of the court. Right? The proper name of the court would be on the court seal. Oh, they don't use those either. I don't believe it's really a true legal process. I think they're just simulating. And that would be color of law, and that would be a civil rights violation under Article 42 of the U.S. Constitution, which is the supreme law of the land. Article 42 of the U.S. Code. Excuse me, not the Constitution. U.S. Code. Okay, so knowing these things, it doesn't help us yet. We still got to find these officers, and who the heck are they? So in the video I did just the other day on Buckley, I'm going to go to the front of this in just a second, but I wanted to show you, if you go in, if you download this document, hey, you can word search it, and you put in the word postmaster, and it says, indeed, as already indicated, Buckley reaffirmed prior decisions that concluded that a postmaster first class and a clerk of the district court were officers of the United States. Well, why don't you download this if you'd like to go to federal court and play, and go show it to the clerk and say, I need to know who they're talking about right here. Go find out and come back and tell me, because the Supreme Court says they're an officer of the United States. They can enforce the laws of the United States. And now we'll give them some. But the first part of this was this. So I think the easiest way to find this is just to Google officers of the United States within the meaning of the appointment clause. If you were to Google that, this would be like the first hit that comes up. If it says April 16th, 2007, hey, you're looking at the right thing. A position to which is delegated by legal authority a portion of the sovereign powers of the federal government and that is continuing is a federal office subject to the Constitution's appointment clause. A person who would hold such a position must be properly made an officer of the United States by being appointed pursuant to the procedure specified in the appointment clause. Well, that sounds pretty simple. Just follow the damn procedure. Well, apparently they're not. So, the appointment clause says the President shall nominate and by and with advice and consent of the Senate shall appoint ambassadors and other public ministers and consuls, judges of the lowercase Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, and in the heads of departments. So for, looks like the major ones, you've got to do it the President, advice and consent of the Senate. Now, what if the senators aren't properly elected? Oh, I've talked about that before, and it really doesn't look like they are. And we're going to take a look at it and see if there's something we can use there to our advantage also. The fact that they're not elected, and hey, that would put us, or that they're not properly elected, them or the U.S. representatives, and therefore we have no representation in Congress, and therefore by the Emancipation Proclamation on January 1st, the President should be making a proclamation of all the states who have not provided a representative to the United States, and that would be the evidence that they're in rebellion against the United States. And then the United States revenue officers, customs officers, could go and confiscate all their property and set the slaves free. And that would be us. So, the appointment clause, as the Supreme Court has explained, reflects more than a frivolous concern for etiquette or protocol. Buckley versus Vallejo again. Rather, the clause limits the exercise of certain kinds of governmental powers to those persons appointed pursuant to specific procedures. Rule of law, that's the procedure. We got a rule of law, here's the rule. Do it this way or it's not lawful. Wasn't done, not lawful. You're not an officer, you don't have any power. Now, if that's being done on purpose, well, that could really muck up your avenues to justice. We could actually say that would be obstruction of justice. I think that's why they do it. Okay, so we think the term officers of the United States as used in Article 2, defined to include all persons who can be said to hold an office under the government, is a term intended to have substantive meaning. We think it fair and important that any appointee exercising significant authority pursuant to the laws of the United States is an officer of the United States and must therefore be appointed in a manner prescribed under Section 2, Clause 2 of that article. And one last section. Applying this understanding, the court in Buckley unanimously held that the appointees clause required that the enforcement, regulatory, and other administrative powers of the Federal Election Commission could properly be exercised only by officers of the United States appointed in conformity with it, with the clause. Because the members of the Commission had not been so appointed, the Commission could not constitutionally exercise these powers. So what did that just tell us? It just said that the members of the Federal Election Commission are unconstitutionally appointed. Well, something's unconstitutional, it could be construed as treason. And so the Federal Election Commission appointees are traitors. They should be arrested, or they should at least be properly appointed. And again, why is it that they wouldn't be properly appointed, right? They probably think they did everything right. I don't know that these people know that that they're being used as tools of the devil or not, but, you know, it is what it is. And I'm going to say it's because of this right here, that the President shall nominate, by and with advice and consent of the Senate, shall appoint ambassadors and other public ministers and consuls, judges of the lowercase Supreme Court, which is different than, where do we see Supreme Court someplace else, right? Where it was proper case Supreme Court. You know, it's like, well, what is the lowercase Supreme Court? Because the Supreme Court should be a legislative court. Because legislative courts can make laws, change laws, abolish laws. All that the judicial court can do is take the law that they've been handed and say, is it constitutional or not? But they can't make it. They can't make it go away, other than to say it's unconstitutional. But if it's never brought to their attention, whether it's unconstitutional or not, it's still the law. You know, it was never brought to their attention. And they don't go out looking for it. Okay, and so anyways, what if the senators aren't properly elected? And we could look real quick just to see what they're supposed to do to be elected. Let me see what that was. Where is that? There we go. So here's Michigan, right? Every state has some kind of laws about being elected. So Michigan compiled law 168-100. A United States lowercase senator shall be elected at the November election held in the year 1958 and the general November election every 6 years thereafter. So actually, whoever this person is the one that would be elected this time around. But a United States uppercase senator shall be elected general November election held 1960, 2 years later. Well, these aren't the same office. I don't believe a lowercase senator and a propercase senator are speaking of the same thing. A United States senator, that way, is a proper noun. United States a proper noun, but senator is a common noun in the lowercase senator. So if these are two different offices made to look to be the same, but you know they're not the same, and the law says in the Constitution you have to have 2 seated senators, every state shall have 2 seated senators, but there's only one, well then you're not properly represented. And therefore the Emancipation Proclamation should be enacted. And that's, the very first article of the Constitution that talks about how many senators you're supposed to have and so forth. But going further, all right, so these senators, certificate of determination by a board of canvassers. So the lowercase senator, right, is supposed to get this certificate of election. Actually, this is the certificate of determination. The board of state canvassers shall determine which candidate for United States Senator has received the greatest number of votes and shall declare such candidate to be duly elected. The said board shall forthwith make and subscribe on its statement of returns a certificate of such determination and deliver the same to the Secretary of State, who shall forthwith deliver a true copy of the certificate to the governor. it shall be the duty of the governor upon the election or appointment of a United States Senator to certify his election or appointment to the President of the Senate of the United States. And again, lowercase President of the lowercase Senate of the proper United States. And the United States is the United States of America. This is a proper nickname or contraction of the United States of America. The United States of America, with the being part of the title, United States, as you see it here, and U.S. all go to the same thing, right? They're describing the same entity. United States of America and USA aren't describing the same thing. They're describing the kingdom of King George III and his successors, as you will see if you go look at the Treaty of Peace of 1783 and read the first paragraph. But nevertheless, so it will be the duty of the governor, upon election, United States Senator to certify. Said certificate shall be under the Great Seal of the state and countersigned by the Secretary of State, and a copy thereof shall be delivered to the person so elected or appointed as a United States Senator. So, there you go. They're supposed to send a copy to the president and also give a copy to the senator. So the senator should have his copy of this certificate. So, hey, write your senator and ask him for his certificate of election. If he doesn't have one, well, then he's not a senator. It's the same with these representatives in Congress. The same thing. It's just a little bit different. Because every 2 years. And it says the secretary shall file in his office and preserve the original certificate statement of determination. That's the same for any office. First of all, these people called the canvassers in Michigan. I don't think they're called canvassers all over. We have state canvassers and county canvassers, depending on the office, but the state canvassers for a U.S. representative, they're going to file that determination of the Board of State Canvassers of the result of the election and shall forthwith execute and cause to be delivered to the person thereby declared to be elected a certificate of election certified by him under the Great Seal of the state. And there we go again. Now this one doesn't say the governor's going to be on it, just the Secretary of State. Who am I to argue? Show it to me. Right? Just follow the procedure. Just rule of law. They're not following the rule of law. And so if they haven't followed these rules, they're not actually in office. And if they're not actually in office, then according to the Emancipation Proclamation, then on the January 1st, 1863, then on the first day of January in the year of our Lord, all persons held as slaves within any state or designated part of the state, and it didn't say people. See, it says all persons held as slaves within any state or designated part of the state, comma, the people whereof shall be in rebellion against the United States. So if they're holding persons slaves or designate them part of the state, then they're considered to be in rebellion against the United States. Well, them making your all capital letter name and them saying that's their property. No, it's not. It's my property. I say it's mine. You took my property and you designated it part of the state. And that's what they did. Instead of them giving it to you, they took control of it. Right? They're acting as your trustee of your property. But I didn't tell them to do it. And so we could talk about adhesion contracts and blah, 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 blah. And I say, well, you know, screw that. It's my damn property. Give it back or put them in prison. Oh, well, here's how you can do it, right? I'm going to say they're holding my property. Now, how do we know? The executive will, on the first day of January, aforesaid by proclamation, designate the states and parts of states, if any, which the people thereof, respectively, shall be in rebellion against the United States. Well, let's get her decided. And the fact that any state or people thereof shall be on that day in good faith represented in Congress in the United States, well, that would mean they have 2 senators there by members chosen therein at elections wherein a majority of the qualified voters of the state shall have participated, shall, in the absence of strong countervailing testimony, be deemed conclusive evidence that such state and such people thereof are not there in rebellion against the United States. Well, I got news for you. I want a head count. I want to see if they are. Because if they ain't, well, then they're in rebellion. And if they're in rebellion, you could go through this rest of this proclamation, and it would talk about this preliminary Emancipation Proclamation, right? Because the one was January 1st, and so on January 1st of 1863, blah, 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 the president did a proclamation, and he said Arkansas, Texas, Louisiana, all these people were in rebellion, right? Okay? And by the virtue, power, purpose, aforesaid, I do order and declare that all persons held as slaves within said designated states and parts states are, and henceforth shall be, free, and that the executive government of the United States, including military, naval authorities thereof, will recognize and maintain the freedom of said persons. We just need to get them to say they're in rebellion, and boom, they have to set us free. But then this went on to talk about this preliminary one, which prepared for the one we just saw. I'm not going to read all these right now. You can go find them yourself. It's not hard to find. Just Google Preliminary Emancipation Proclamation, September 22, 1862. In this, it will tell you about another act, which ended up being called the Second Confiscation Act. Although they don't call it that in the thing, it takes a little bit. I think they just give the date that it was done. An act to suppress insurrection, to punish treason and rebellion, to seize and confiscate the property of rebels and of other purposes, or for other purposes, be enacted by the Senate, House of Representatives of the United States of America, Congress assembled, that every person who shall hereafter commit a crime, treason, against the United States, and shall be adjudged guilty thereof, shall suffer death. Or 5 years, it goes on to say, and take their property. And then it goes on to kind of say who these people might be and what they might be doing. Section 5. That to ensure the speedy termination of the present rebellion, it shall be the duty of the President of the United States. Now, notice, this says President of the United States. Not President of the United States of America, which is what the proclamation, the Emancipation Proclamation says. We'll look at that in a minute. So, could be the same guy, president of two different agencies, because the United States and the United States of America aren't the same. To cause the seizure of all estates and property, money, stocks, credits, effects of persons hereinafter named in this section, and to apply and use the same and proceed thereof in the support of the Army of the United States. That is to say, so whoever they mention in here, if that state's in rebellion, they're going to go seize all their property. Of any person hereinafter acting as an officer of the Army or Navy of the rebels in the arms against the government of the United States. Of any person hereinafter acting as President, Vice President, Member of Congress, Judge of any court, Cabinet Officer, Foreign Minister, Commissioner, or Consul of so-called Confederate States of America. Of any person acting as governor of a state, member of a convention or legislature, a judge of any court, or of any so-called Confederate States of America. Of any person who, having held an office of honor, trust, profit in the United States, shall hereafter hold an office so-called in the Confederate States of America. Of any person herein hold any office or agency under the government of the so-called Confederate States of America, and under the several states of said Confederacy, or the laws thereof, whether such office or agency be national, state, municipal, in its name and character, provided that persons thirdly, fourthly, fifthly above described shall have accepted their appointment or election since the date pretended ordinance of succession of the state, or shall have taken an oath of allegiance to or support the Constitution of the so-called Confederate States. On and on and on. So, any person who owning property with in any loyal state or territory of the United States or in any District of Columbia shall hereafter assist and give aid and comfort to rebellion, and all sales, transfers, conveyances of such property shall be null and void, and it shall be sufficient bar to any suit brought by such person for the possession or use of such property of any to allege prove that he is one of the persons described in the section. All that to say, they could go take their property. Now, the Civil War was never a declared war. It was always an insurrection, and it didn't have a peace treaty. It just had an armistice, and an armistice is nothing more than a prolonged ceasefire. So the insurrection has never gone away. The idea of the Emancipation Proclamation was to give them, over a period of time, to slowly, everybody chill out. You can't have slaves anymore. You're going to have to figure out another way to do it. You're going to have to give them a certificate and let them go. And, and if they want to work for you, well, then you're going to have to pay them a wage. Somebody made that decision. Well, something's happened, and we're back, into the same thing where now they've taken our property and they've confiscated it, and they are in violation of the Emancipation Proclamation because they are not actually have representatives in Congress. They're just usurpers. They're acting like they're there. So, what are we going to do about all this? Did I point out one thing? Okay. So if you were, I really suggest that you download this thing. So look at again, right? Officers, United States, within the meaning of the clause, appointment clause. And you can put in different words like postmaster or justice of the peace. All right, so I just put in justice. Yeah, I guess I better not. There'll probably be too many of those. Justice of. Recognized earlier that Justice of the Peace of the District of Columbia was an officer of the United States. Well, okay. Now, the District of Columbia is considered a state, right? So the Justice of the Peace of a state is an officer of the United States. That's what I think it means. Justice of the Peace holds an office. All the judges of the General Court appear to agree that a Justice of the Peace exercised delegated sovereign authority. Well, that's all we're looking for, right? So if they have delegated sovereign authority, then basically they have to enforce the laws they have to agree that the supreme law is the laws of the United States, the Constitution and the laws of the United States, and that they have a duty to enforce them. So one of the things we saw in there was that it said the clerk of the district court, and I closed it and I don't want to go try to find it again. But now what we can do with that is, I know a lot of people like to put paperwork into, or do court cases in the federal, which I guess would be okay. I just don't believe it should be the $400 federal. It should be these miscellaneous cases. Miscellaneous case numbers are normally assigned to a variety of matters filed with the court which are not considered a civil case. They are ancillary or supplementary proceedings not defined as civil actions. If the miscellaneous case is contested before a district judge, it then receives a civil case number. So if the miscellaneous case is contested before a district judge, it then receives a civil case number. Until then, it's not going to have one. Miscellaneous cases could be directly or indirectly related to a case, such as an application to perpetuate testimony as defined in Rule 27, blah, 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 blah. Miscellaneous actions require resolution through a judicial system. So it can't be administrative. It had to be judicial. Now, these are like $46 to put in. Not even that. Let's see what this one says. That was a little bit harder to read than the one I found before. Get that one up. Now, this is the important stuff. All right, because here, the United States should not be charged fees under this schedule. So what does that mean? It means make the United States of America the plaintiff. In a criminal action, in a crime, the crime is against the state. You may be the victim and an ex rel plaintiff, but the crime is against the laws of the state, so the United States of America is the plaintiff and you're ex rel. So the United States of America, ex-rel Robert Allen Rutluski, plaintiff, versus whoever it is. But even if you just did it yourself, for filing of a document that is not related to a pending case or proceeding, it's $46. Well, if you're putting in the very first piece of paper into a court case, there is no pending case or proceeding. So it'd be $46. That's how you would put your complaint in. If you want to do a Title 42 action, go put it in as a miscellaneous filing and pay the $46. Or go take it to the clerk and make the United States of America the plaintiff, and you ex-rel, and give it to the clerk of the district court, who is an officer of the United States who has a duty to enforce the laws of the United States. To not do so is obstruction of justice under Title 42 Civil Rights section. I think it's Chapter 21. Right? So the United States of America never pays. So one way to do it is make the United States of America the plaintiff and your ex-rel, and the state will get you your remedy. That's its duty. If you still want to do it because you want to do it yourself, then go put it in as for filing any document that is not related to a pending case or proceeding for $46. Or, way down here at the bottom, administrative fee for filing a civil action suit or proceeding in a district court is $50. The fee covers not only this fee does not apply to applications for writ of habeas corpus or person granted form proper status under blah, blah, blah. Okay, so you're in a court right now, right? Tell them you want to put it here. Go show it to them and say, here's $50. Administrative fee for filing a civil action in a district court. $50. That's what I want to do. And so if there's already one ongoing, see, the one you might be in now is in the court. And we want to get rid of the in the and have it be District Court of the United States or something like that. And that would cost you, according to this, administrative fee for filing a civil action, suit, or proceeding in a district court, lowercase district court, is $50. Somebody go try it. Tell me what they do. Right? I don't have a car. I don't have any money. All right, that's why, hey, if you can, man, I really need you guys to help. Just stop right now and pause it, write that down, PayPal account or snail mail, and help a brother out. Okay. What else did I have? How to file a miscellaneous case electronically. Now, I don't think that people, unless you're an attorney, can do this, right? But what this shows you is, if you could, you go to Initial Pleadings and Services, and it says go to Complaints and Other Initiating Documents. Under the pleading and service, click CV, complaints and other initiating. We just said that, right? And when you look at this and you have these choices, case opening document for miscellaneous case. Well, that's the very first piece of paper. That's a complaint. It's just not the complaint with the civil cover sheet, which is going to be the $400 case. It's the complaint in a miscellaneous case for $46. Or the United States of America and do it for free. And tell them you want to file it as a miscellaneous case and make the United States of America the THE part of the word. Go look at the Articles of Confederation and Perpetual Union, very first article. The style of this confederation shall be the United States of America, comma, ex-rel, your name, proper name, Robert Allen Rutluski in my case, plaintiff, v, whoever it is. And so if it's against the IRS, don't say the IRS, say it's against the dude at the top of the IRS. The guy in charge it's his job. This is the other thing about, the criminal side is you can get directly to the person involved. It'll pierce the veil. Let's put it that way. There is no immunity. You're going to pierce the veil and not say it's against the IRS. You're going to say it's against whatever his name is, commissioner of the IRS. And then they'll serve the papers on him. So, I just found this stuff by just Google, miscellaneous, federal miscellaneous cases. And something like that. Just as many different things as you can think of. Filing, miscellaneous case, federal court, whatever it is. I think you could do the same thing even at the local court by going to the officer or the clerk that takes the evidence. Now, I did a couple of videos ago, where I was reading out of this book. It was talking about Old English law, which is what our laws are based on, and it pointed out very clearly that the whole system of English law is based on the fact that there's one central court. Everything goes to the central court, and it gets dispersed from there. They'll decide what to do with it. But if you have a complaint, you're supposed to send it to the king's court, right, to the royal court. Well, what's your royal court? And so the way that was done is they had royal officers. We might call them justices of the peace. We might call them constables. We might call them whatever they're called. But they're state officers, right? They're not local court officers. They're officers of the state that work at the court. And in Old English law, the bailiff was the clerk of the court. And that's common law. We're trying to get to the common law side, right? So you would give your paperwork to the bailiff. Now, the bailiff isn't necessarily the guy you think it is when you go into court, although that could be him or he could work for him, but there's like one bailiff who's in charge. And he would be like he could be the top deputy sheriff. Be a lieutenant. Something like that. As we found in Illinois, they actually have a chief civil bailiff and a chief criminal bailiff. And then they're supposed to have some have clerks that work for them and so forth. And it's like, okay, well, that's who you would take your complaint to, because the bailiff's job is to serve papers, right? To serve process. Well, again, the very first piece of paper in a process is the complaint. So in my mind, you give it to the bailiff. He logs it in his book, just like a notary. Now, that's like that would be the same as the coroner recording the plea of the crown back in the day and giving it to the sheriff, and now the sheriff has to do something with it because it's in the coroner's book and he's a royal officer. We're not getting our complaints in the right book. We're not putting any paperwork in the right jurisdiction. And so it isn't that you're doing the paperwork wrong, you're giving it to the wrong damn person. That's what I'm thinking it is. And we have heard that there are people that are called evidence clerks, exhibit clerks. Who do I need to talk to file paperwork into my case under seal? That's what we're talking about. This is going to go under seal, right? What does that mean, under seal? Well, it's going to have a damn court seal on it. The other paperwork doesn't have court seals. It's not even in court because it doesn't have a court seal on it. We need to have a court seal on it. That's where the court case is, where the damn paper where the court seals are. And that's where you're trying to get it into. Okay. Hang on just a second. Okay. So, again, this is a matter of, well, who are the officers of the United States who have a duty to enforce the laws of the United States? You got to find them. I didn't know that this even existed until last couple of weeks, and it's called the Federal Executive Boards, and there's like 28 of them, I believe, across the country. It was a program established by the President, Directive 1961 by John F. Kennedy, where he's basically saying, hey, 85% of the federal employees are outside of D.C., so we should have these regional offices, basically. And so everybody within that region, who's ever the highest ranking person of whatever federal agency it is ex officio a member of this board. And they get together 3, 4, or 4 times a year or something like that, and more if necessary, but it's a board. And the board of these people then elect one of their own to be the president of the board and secretary of the board, treasurer of the board. And then I think the GSA supplies somebody to be called the executive director. They want all your stuff to go through the executive director and blah, 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 and so forth and so on. Well, so Detroit had one, right? And so, this would mean like, the FBI and, the judicial, the Department of Justice and Department of Health and, and many different agencies as there are, if they have a representative within whatever this territorial limit is, then they are, and they're the highest ranking, then they're a member of this board. So it's like, well, okay, well, these should all be officers of the United States. So I should be able to send a complaint to the person that is the executive director and say, hey, why don't you give this to your people and find out? And I did that, late last week, and I'm waiting to hear. But in the meantime, I've moved on because this is just one of the things that I found where there could be officers. The other one I just told you, well, it says a postmaster. First class is an officer of the United States, and so is the clerk of the district court. So there's some more possibilities. Because the pathway is narrow. So I did send complaints here, and I was going to read those complaints, but I'm not going to, because I moved on a little bit further, and what I found was also that the Coast Guard are officers, that law enforcement officers of the United States. So the United States Coast Guard is a branch of the United States Armed Forces and one of the country's 7 uniformed services. The Coast Guard is a maritime, military, multi-mission service unique among U.S. military branches for having a maritime and law enforcement mission with jurisdiction in both domestic and international waters, and a federal regulatory agency mission as part of its mission set. Because they're treasury agents. They're revenuers. Authority as law enforcement agency. Title 14, USC, United States Code, Section 2, authorizes Coast Guard to enforce the U.S. federal laws. Well, that's what I'm trying to get done. The authority is further defined in Title 14, USC, Section 89, which gives law enforcement powers to all Coast Guard commissioned officers, warrant officers, and petty officers. Well, that's what I need. Who can enforce the laws of the United States? Unlike the other branches of the United States Armed Forces, which are prevented from acting in law enforcement capacity by Title 18 U.S.C. Section 1385, the Posse Comitatus Act, and Department of Defense policy, the Coast Guard is exempt from and not subject to the restrictions of the Posse Comitatus Act. Well, then they can enforce the laws of the United States within the boundaries of the United States. Further, law enforcement authority is given by Title 14 U.S.C. Section 143 and Title 19 U.S.C. Section 1401, which empower U.S. Coast Guard active and reserve commissioned officers, warrant officers, and petty officers as federal customs agents. This places them under Title 19 U.S.C. Section 1589A, which grants customs officers general federal law enforcement authority, including the authority to carry a firearm, execute and serve any order, warrant, subpoena, summons, or other process issued under the authority of the United States, make an arrest without warrant for any offense against the United States committed in the officer's presence, or a felony cognizable under the laws of the United States committed outside of the officer's presence, if the officer has reasonable grounds to believe that the person to be arrested has committed or is committing a felony, and perform any other law enforcement duty that the Secretary of Homeland Security may designate. So, what does that mean? It means, well, first of all, what is a felony? A felony is when they take all your property, life and property. Right, that's really what a felony is. Criminal forfeiture is what happens if there's a felony involved. They take your property. So I don't know. I don't know if these have numbers on them. Are they 18 USC? Are we talking the Constitution? What are we talking about? What we did find out is anything that's cognizable under the laws of the United States. So let's just go with that. What does the 18 USC say? Right? Anything that's I don't know if 18 USC says it, but anything that has jail time greater than 1 year is considered a felony. And this is kind of interesting. This flag here, this bigger one, that's the customs flag, and this one here is the Coast Guard flag. which is the customs flag with a Coast Guard symbol on it. And sure enough, the Coast Guard started out as the Customs or the Revenue Cutter Service, and it joined together with the Life-Saving Service and became the Coast Guard. But they didn't give up either of the powers. They're still revenue agents. They are the Internal Revenue. 14 U.S. Code 143, Commission, Warrant, Petty Officer of the Coast Guard are deemed to be officers of the Customs. Officers of the Customs. Look at that. That's lowercase. It's like, what does that mean? Because lowercase customs, if you were to go look in Webster's Dictionary, 1828, you would be talking about the unwritten law of reason. The unwritten laws that we work under. And the unwritten law of reason is the laws of equity. Maxes of equity. So, okay, let's go enforce those. Deemed to be officers of the customs, and when so acting shall, insofar as performance of the duties relating to customs law are concerned, be subject to regulations issued by the Secretary of Treasury governing officers of the customs. Oh, they work for the Secretary of Treasury. I wonder if the Secretary of Treasury could be the lowercase president of the United States, because there's something about Treasury that's different than other places. So these are the people that we should be taking, as you'll see. I mean, this is my idea. Okay, well then, I've gone to the IRS and pointed out people that have EIN numbers don't have the determination letter that backs up who they say they are, and they haven't done anything. So I did the same thing with these guys. And let me show you what I did. All right, so I just sent this out yesterday. And I did it by email. And hey, I don't know if this stuff needs to be signed. I don't know how tight the rule of law is, right? What I want is an officer of the United States to come and, use a little common sense and say, yeah, it looks like they're committing a crime. We'll take it from here. So unconstitutionally appointed officers of the United States, election fraud, insurrection, rebellion, treason, and other felonies against the laws of the United States. To the 9th Coast Guard District, U.S. Coast Guard, dear reader, a.k.a. guardians. They like to call themselves guardians. Now, every part of the United States is in a district. I don't care if you're in the desert, you're in a Coast Guard district. I, Robert Allen Wertlewski, relator for the United States of America, accept your oath of office, bind you to the same, remind you of your constitutional duties, and thank you for your service. As for myself, I'm a 10-year active duty U.S. veteran, owner of the legal name Robert Allen Wertlewski, and Social Security number 374506794. Those are mine. I claim them. Now serving Lord Emmanuel, the Christ Jesus of Nazareth, only begotten Son of Lord Almighty, anointed to speak in his name. Lord Almighty calls his ordained civil authority to save lives. The United States of America calls you to enforce its laws. A man-made disaster requiring immediate emergency management has been created by the unconstitutional appointment of officers in the United States, along with usurpers controlling elected offices as part of a worldwide antitrust scheme that obstructs justice in order to extort and embezzle our posterity and enslave our persons. This is not a drill. Get out your feet off the desk and call your commander. By the intentional omission of material facts, the requirements of the Appointment Clause of the Constitution is not complied with, ensuring the appointed officer is impotent to execute his office, even if the person is unconscious of the fact the official record confirms that their appointment is unconstitutional. They, the appointee, may not know it, but rest assured someone does, and this someone, the devil's disciple, has neither yours nor my best interests at heart. Someone wants unconstitutionally appointed officers in office to ensure that said officers have no real power, instead becoming counter-trolls, blocking the path to justice. Do you see how easy this is? Just put unqualified people into office and then they can't do nothing. Can't stop them. In memorandum, which is the thing we were reading earlier, opinion for general counsels, the executive branch, dated April 16, 2007. Hey, that was, 9 years ago. Dealing with the office of the United States within the meaning of the Appointment Clause is found, and this is the nuts and bolts right here. The court in Buckley unanimously held that the Appointment Clause required that the enforcement, regulatory, and administrative powers of the Federal Election Commission could be properly could properly be exercised only by officers of the United States appointed in conformity with the clause. Period. Because the members of the commission had not been so appointed, the commission could not constantly exercise these powers. Shit. That means they're unconstitutionally appointed. And so they can't do what they're supposed to do. Whatever the commission was established for, they can't exercise its powers. Unconstitutionally appointed officers of the United States acting as commissioners of the Federal Election Commission are unable to exercise the powers of their office because of a civil disability or arbitrary rule of law. Meaning, this federal agency, the FEC, created to regulate campaign financing, is powerless to do so because its commissioners are unconstitutionally appointed. Do I need to say it again? Instead of stopping tax-exempt Section 501c3 corporations from participating in campaign financing, the FEC gives them committee numbers to easier track who they help elect. Planned Parenthood Action Fund Incorporated has a committee ID established with the Federal Election Commission. This Section 501c4 has the same principal officer as Planned Parenthood Federation of America. There's her address and so forth. A presumed 501c3 having FEIN 1316444147. Planned Parenthood Federation of America, Inc. is the newsworthy corporation that is selling God's yet-to-be-born creations for profit and dinner. You know who I'm talking about. From the IRS website, under the Internal Revenue Code, all 501c3 organizations are absolutely prohibited from directly or indirectly participating in or intervening in any political campaign on behalf of or in opposition to any candidate for elective public office. Contributions to public campaign funds or public statements of position, verbal or written, made on behalf of an organization in favor of the opposition to any candidate for public office clearly violate the prohibition against political campaign activity. Violating this prohibition may result in denial or revocation of tax-exempt status and imposition of certain excise taxes. Check these EINs. These entities' FEINs. 13-353-9048, 13-1644147. That's an order against the IRS records that I am confident you will find that neither has ever received a ruling from the IRS acknowledging that the IRS agreement that the entity is actually exempt. It isn't good enough just to put it in the application. They got to say they agree. From the IRS website, a ruling or determination letter will be issued to your organization. Will be issued to your organization, right? If its application and supporting documents establish that it meets the particular requirements of the section in which it is claiming exemption. However, the IRS will not ordinarily issue rulings or determination letters recognizing exemption if an issue involving the organization's exempt status is pending in litigation or is under consideration within the IRS. In other words, if they have no ruling, have not paid their customs, duties, fees, and the like, they are not tax exempt. They are tax evaders. Doesn't the Coast Guard have something to do with collecting revenue in the United States? It's a rhetorical question. Of course you do. And as validly appointed law enforcement officers of the United States, it's your duty to investigate and adjudicate. Or will you sit on your thumbs, maybe work on your knot-tying merit badges, instead of freeing you and your children, parents, granny, friends, and family from a demonically controlled criminal syndicate rebelling against the laws of the United States? What would Jesus do? What would he have you do? That's the important question. What the fuck are you doing, brother? Jesus is waiting for you to step up. In 2006, the recording secretary of the Federal Election Commission, Darlene Harris, certified that the commission found reason to believe that Planned Parenthood Federation of America, Incorporated, the one that likes to sell babies for, like unborn duck eggs so people can eat them, violated 2 U.S.C. subsection 441B, copy, Muir, 5808, attached to this mailing. I show you. But this law says, 2 United States Code 441B, it is unlawful. It is unlawful for any national bank or any corporation organized by authority of any law of Congress to make contributions or expenditures in connection with any election to any public office. Hey, I don't think they're allowed to be involved in campaign financing. What do you think? Unfortunately, the Federal Election Commission took no further action for this violation of the laws of the United States. In other words, individuals appointed by the President of the United States to execute and enforce the election laws of the United States, that would be the Federal Election Commission, did not prosecute the violation of the laws of the United States, and instead simulated a legal process by color of law. This obstruction of justice has resulted in the blood of thousands of innocent creations of God on their hands, and a lawless society of satanic sock puppets to terrorize the peaceful inhabitants of the United States. The actions of the Federal Election Commission are those of traitors, not officers of the United States. How many more unconstitutionally appointed officers are there? The answer is, well, at least it seems, there's most of them. Attorneys acting as judges, police officers, deputy sheriffs, marshals, FBI, deputy Department of Justice, officers of the court, officers of the legislature, officers of the executive, all use names other than the true name and are only acting in an official capacity. They are de facto agents rebelling against the laws of the United States. They can only simulate legal processes under color of law, and their doing so is an international crime against humanity, terrorism, insurrection, rebellion, treason. You get the picture. Military personnel, on the other hand, are allowed under Title 10 of the U.S. Code to serve under an assumed name, fictitious name, C10 U.S.C. subsection 1551. Elected officers are no better. No senator or U.S. representative can prove that they were validly elected. They do not have a certificate of election under their state's Great Seal, do not have a valid oath of office, and are not on any official role of representative. Title II of the U.S. Code pertains to the Congress, and within the first 26 sections are the few steps that must be completed before a senator or congressman can be seated as elected, and had an asterisk. It's possible one senator from each state is actually elected. This depends on rules of grammar because it was lowercase senator, and yet to be proven. So what I need to do is go back and see who's, because these are every 6 years, and you only have 2, so some years when there's an election, you wouldn't have anybody being elected. But 1958, this would be the year for those people, so I don't know who it is that's up this time. Well, whoever it is, to see if they have it. But, I can't get anybody to do anything. I need an officer of the United States to go ask these questions. Yearly since 1863, on January 1st, in accordance with the Emancipation Proclamation, the President of the United States of America is to issue a proclamation naming the states currently in rebellion against the federal government, evidenced by the lack of representatives sitting in Congress on that day. Then have his agents of the customs, hey, that would be Coast Guard, confiscate the property of the rebellious people. Perhaps it's time for a head count. Let's go, check the books, see how many of these people actually did the few things they need to do and are actually seated as congressmen and senators. And it could be done today, and this whole fucking crazy ass shit could be done. I just need an officer of the United States who's going to go and do their duty. And I know you're out there. We just haven't met yet. Other elected officers of the state, county, or local are no better. None of them has a valid oath of office, nor have they filed an official bond or received a certificate of election in accordance with any state's election laws. It's all a frickin' fraud. This conduct is a violation of Article 6 protections under the Constitution. Need I say more? Did you call your commander yet? Just audit the procedure, election laws of your state, making sure they give you official documents under official seal, or it is not official. Until you can check it off, it doesn't happen. Just go to your laws and put a line next to each one. And unless you can put a check box, say, yep, that's been done, well, then they haven't filed a procedure. They didn't follow the rule of law. right? We need it said that they didn't do it. Courts are not using court seals, nor are the proper names of a court having state or the proper name of a court having state or federal jurisdiction. Again, there is no court named in the 16th Judicial Court. No, there may be a 16th Judicial Court, but there's no court called in the 16th Judicial Court. That's not its proper name. Presumed legal proceedings have omissions of material facts. Presumed attorneys at law have not subscribed the required oath of office and are practicing without license. Traffic court is about commerce, not traveling. Just go to Webster's. Google Webster's 1828, right? You can find a copy of the dictionary online and put in the word traffic, and you'll see there's nothing in there about driving a car. It's all about commerce, commerce, commerce. It's a commerce court. The lender never lent you any money in your home. They didn't sign the contract. Nope, they didn't. They fly flags with gold fringe. Are these military flags or just wall decorations? It is never any list of bullshit, half-true submissions and material facts using Commerce Clause as a weapon against the innocent. And. Some of these individuals are Satan's spawn and destined for hell, just the way it is. Others just need fear of God restored, and yet others need an exorcism. God Almighty wants you, that you would be the Coast Guard, to save the immortal lives of those who can be saved. To not attempt to save lives is not in your creed. I read it. Even the County of Kent, Michigan, FEIN 38-6004862, is not the government it claims to be. Kent County is the administrative arm of the state government, but the County of Kent gets the federal funding. And according to its yearly financials, assets of the county exceeded its liabilities by approximately $575 million. Why does the county have a $500 million surplus, yet taxes go up? School districts, cities, villages, townships, any and all special taxing districts file a yearly comprehensive annual financial report. In each and every case, huge surpluses sit idle in funds that the entity administers but never uses to pay the debts. Instead, they come asking for more. They never extinguish the debt. Instead, they make minimal payments and bank the rest. They execute and enforce unconstitutional statutory liens, turning all nationals of the United States into bond servants, stripping them of their constitutional protections. You, the Coast Guard, can be the ones to overturn the money changers' tables, cancel the national debts, and return the surplus to the possessors of unalienable rights. That would be us. The yearly County of Kent, Michigan Federal Single Audit Act compliance, intended to account for federal funds granted, was done by an unqualified company that claims to be a certified public accountant, but it is not. Not only is it not a certified public accounting firm, it's not even a properly formed corporation. Yes, Guardian, they do the same where you live, where your folks live, where your granny lives. Ask your county for their W-9, request for taxpayer identification number and certification, and run the EIN number with the IRS to see if they have received a determination letter from the IRS confirming that the IRS agrees that the holder of the FEIN is, in fact, the government. From the IRS website, in order for a government entity to receive a determination of its status as a political subdivision, instrumentality of government, or whether its revenue is exempt under Internal Revenue Code Section 115, it must obtain a letter ruling by following the procedures prescribed in Revenue Procedure 2012-1 or its successor. There is a fee associated with obtaining the letter ruling. Hey, then there'll be a receipt. Where's the receipt? I'll attach to this email another complaint I recently submitted to the Detroit Federal Executive Board covering these issues in greater detail, because the Federal Executive Board has yet to take action, I can only speculate these civil officers in the United States have not been properly appointed and cannot exercise the powers of their office, or they are willing parties to an ongoing rebellion and insurrection. There is much more to this story I wish to share, but for now let's see if the coasties are ready to enforce the laws of the United States. A court of law can lawfully appoint officers in the United States, so gear up your courts and start putting these unconstitutionally appointed officers constitutionally in their office or in prison as the situation dictates. I have given you probable cause to investigate this target-rich environment. Run the FEIN numbers of state, county, local government agencies, audit their financials and the firms hired to compile them. Run the FEINs of all corporations that have ever filed an application with the IRS for tax-exempt status, and then bust their asses if they don't have a determination letter issued by the IRS, and then return the unjust enrichment to the victims. The United States of America is depending on you, and God is waiting for the civil authority He ordained to fulfill its mission. So get cracking. In closing, in accordance with the Articles of Confederation and Perpetual Union, the style of the Confederacy shall be the United States of America, while the kingdom that the successors of King George III claimed in the Paris Peace Treaty of 1783 is United States of America. Right? No, the. The state of Michigan is the free and independent state conforming to the Act of Congress commonly known as the Northwest Ordinance, while state of Michigan boundaries do not comply, making it illegitimate. Kent County, Michigan is a political subdivision of the state of Michigan, not County of Kent. Oakfield is the township in Kent County, not township of Oakfield. Passports do not name herein any national or citizen of the United States. If they did, your proper name, Robert Allen Rutluski, would appear above the signature line. Instead, the inside front cover has the captive resident alien bondservant, Rutluski Robert Allen, from King George III's United States of America information. The Social Security Administration conspired with others to deny access to each and everyone's one share of the public trust by putting your one share of the public trust in an assumed name, Robert A. Rutluski, instead of the proper name, Robert Allen Rutluski, clouding the title of ownership, and deny the rightful owner from claiming his property. Our birth name has never been registered in the United States of America. Instead of going to the state registrar, the record of birth never left your birth county. It remains in the office of the clerk of the county of. Even now, as adults, you are not allowed the status of registered qualified elector in your township, city, or village. Even your DD 214 you will someday be issued uses your bond servant name, Rutluski Robert Allen, effectively denying your faithful service and access to all benefits due an honorably discharged service member. We have been disenfranchised of our unalienable rights by omission of our proper name from the official records, and I wish the Coast Guard to do its duty, including seeing that I am installed in my office of elector, domiciled in the elemental republic that I inhabit, and my having full control of my share of the public trust and all benefits due an honorably discharged member of the armed forces. I declare on penalty of perjury my belief the foregoing true and correct, executed on April 6, 2016. I signed the one, Robert Allen Rutluski, Officer of Christ, because I do hold the office of Christ, priest, prophet, and king, anointed by God. Amen. Father, Son, Holy Ghost. Okay, I want to show you just one more thing and we'll be done. Hang on just a second. Okay, let's look at a few pieces of paper that I just talked about in that talk. So here's the, hopefully, the EIN, right? So the W-9 for my county. I just called the county, so I want a copy of your EIN for the, I said Kent County because that's what it should be, and this is what they sent me. Name is shown on your income tax return, County of Kent. That's who they're saying it is. There's the employee identification number, the FEIN, Federal Employee Identification Number. And then if you go down lower, this is the certificate, and it's done under penalty of perjury. And it says, under penalties of perjury, I certify that the number shown on this form is my correct taxpayer identification number. Well, it's signed by Brooks Smith. And this isn't Brooks Smith's number. This, if anything, is the County of Kent's number. So this should be a seal for the County of Kent, or for the County of Kent by Brooks Smith or something like that, but it's not Brooks Smith. You know, this doesn't say who that is, so Brooks Smith just committed perjury. So here's the W-9, right? So this is what we're talking about, customs agents, and then take this number here and give it to the IRS and say, hey, I want to know if you've ever issued a determination letter against this number. And you have all the frickin' evidence you need. After that, you just you'll start. The string will be unraveling. This is the letter, or this is the finding before the Federal Election Commission, the Muir 5808, in which it says, I, Darlene Harris, Recording Secretary for the Federal Election Commission, Executive Session September 12, 2006, do hereby certify that the Commission decided by a vote of 4-2 on amended pre-trial tally to take the following actions and RAD referral, whatever it is. Find reason to believe Planned Parenthood Action Fund Incorporated, PAC, and Chris Korsmo, it's in his official capacity as treasurer, violated 2 USC 434B. And then they violated 2 USC 441B. And then found reason to believe that Planned Parenthood Federation of America violated 2 USC 441B, admonishing this respondent but taking no further action. Well, this is the umbrella company, the 501c3 that's not supposed to be involved in campaign financing, and the Federal Election Commission just said they were, but didn't do anything about it. That just don't seem right, people. Okay, and just real quick. So on a passport it says the Secretary of State of the United States of America. So United States of America, again, that's King George. Hereby requests all whom it may concern to permit the citizen national of the United States. It doesn't say United States of America. It says the United States here named herein to pass without delay or hindrance, and in case of need be given all lawful and aid and protection. And I believe right where this space is, right here, is where Robert Allen Rutluski should have been printed, above the signature line. However, right, because this says herein, so from here in, this is going into the book. This here is here out. This is the cover. This is the inside cover, where it says United States of America, USA, Rutluski, Robert Allen. Place of birth, Michigan, U.S.A. Well, none of this is me. Somehow it got to be me. And right, this is the stub off of a Social Security card, and on the back of this stub it says detach this portion from the upper half of the card and keep it in a safe place. Well, I did, or somebody did. It wasn't me. I was a child. Your name and Social Security account number appear on the other side. Do they now? Let's go look. So we flipped it over, and this number was here. Well, that's my number. And here's the name, Robert A. Rutluski. Well, again, that isn't me. Where'd they get that from? My mom and dad didn't send them any paper with the middle initial. Right? At the time, I mean, I put this in later, signed it, but before that, Robert A. Rutluski, well, he's, according to the Social Security, he is the owner of this account. That's crazy. And if you're prior service and you look at your DD-214 name, Ritluski, comma, Robert Allen. Now look at last, first, middle is in parentheses, but that isn't what it asks for. It asks for your name. And my name isn't Ritluski Robert Allen. It's Robert Allen Ritluski. And so this is one of the things I want to get switched. But, I mean, this is what they do to ensure that they don't use your proper person name on any official documents anywhere, because then they'd have to admit that you exist. And they don't want to do that. So, okay, well, that's what I had. I mainly wanted to show the complaint that I had done and make a public record of it. But, it's a matter of finding people that are officers of the United States. And what we have seen is, well, that should be a justice of the peace, and it should be a postmaster first class, and it should be a clerk of the district court. And if you go to a miscellaneous filing, it's using lowercase district court as the thing, so that would be the clerk, and that person there, if you showed the thing from Buckley to, said, well, this says you're an officer of the United States. Right? Enforce the law. I just think that that's, the supreme law of the land is the federal law. That's what we should be using, but it's not the court they keep sending you to, because there is no in the name of a proper court. It is the district court of the United States. Not in the district court, the district court of the United States. Or district court, I'd have to go look myself to know for sure, but you know what I'm saying? And that's all they do. It's all wordplay. Right? Lie, cheat, steal. Mostly done by omission. Not out and out lies as much as just by omitting material facts, which is a false statement under 18 U.S.C. 1001. And so anything they do because they lie is a false statement, and, well, I don't need to have any other reason. Doesn't matter what else they did, it's a false statement in a federal matter. They get federal funding. Go look at their CAFR account. All right, that kind of stuff. In fact, let me just a look here. So you know where to go look at this stuff, right? You can download these CAFR accounts. In fact, I'm sure that in here we could find their EIN number, right? But that isn't what I was getting it for. So here's the comprehensive annual financial report, year ended December 31st, 2014, County of Kent, Michigan. All right, but let's go read it. It says, to the Board of Commissioners and the citizens of Kent County. Well, I thought it was County of Kent. How come they're sending it to the citizens of Kent County? Who is County of Kent anyways? I don't know. I'm trying to remember what page that was on. And here's Riemann Robinson. This is the people that say they're CPAs that are not. Here we go. Management discussion and analysis, right? Go find this page. Just go to the highlights, right? First of all, it says everything in here is indicated, unless otherwise indicated, are thousands of dollars. So add 3 zeros to everything. The assets of the county exceeded its liabilities at the close of the most recent fiscal year by $547,588,000. Well, that'd be $547,588,000. The government total net position increased by $18,822,000. At the close of the current fiscal year, the county's government funds reported combination ending balances of $93 million. Of which, $43 million is unassigned fund balance. At the end of the current fiscal year, the unassigned fund balance of the general fund was $42 million. So I got a general fund that's got $42 million in it that's not assigned anything. Total government-wide liabilities increased by approximately $16 million during the current year, fiscal year. Liabilities for government activities increased approximately $3.5 million. And liabilities decreased by About 13 million business type activities. Yeah, I can't. What are you going to do? How come these people have a $500 million sitting in the bank and they're still coming and asking for more? And you can go to your school district and find theirs. You can find your townships. You can find your cities, your counties. You can find one for the state. You can find it for all these different agencies. And well, there you are. I wonder if you can find the EIN. That's probably EIN is used in Bean. Maybe it's FEIN. Well, I have to find it some other way. So there's lots of shady stuff going on in the background. Don't let anybody tell you everything's legit. Don't believe them. And I'm looking for an officer in the United States to come and take my complaint. Okay, we'll see ya. Thanks.